Good afternoon. My name is Matthew Talbot, and I'm an elder law attorney in Walnut Creek handling elder abuse cases. And today what I wanted to talk about was flipping the burden of proof. And this is an extremely important thing in elder abuse cases because if there's someone trying to say that a document, a will or a trust, is an invalid document because the person who executed it was under the undue influence of somebody else, the abuser, then that person who is making those allegations has to prove the undue influence. And that can be difficult sometimes because undue influence tends to happen behind closed doors. It tends not to be written down, and there is not a lot of evidence to prove it. So one tool in the arsenal of someone trying to prove undue influence is to flip the burden. So instead of the person making the allegations having to prove undue influence, the alleged abuser has to disprove undue influence and show that it was signed of the free will of the decedent, the dead person who executed the document. This can be tough to do. So flipping the burden is huge. So this comes out of a case called the Estate of Mann, and excuse me, there's a 3-factor test that you have to look at in determining whether or not someone can flip the burden. And the first factor is determining if the alleged abuser was in a confidential relationship with the alleged victim. Confidential relationship can be hard to define, but you want to look to see if they were in a fiduciary relationship, if they were in a caregiving relationship, if they were close family members, father-daughter relationship, brother-sister relationship. Those can be part of a confidential relationship. So that's the first factor. If that factor is met, then the second factor is whether or not the victim actively assisted in the procuring, drafting of the document. So what that means is if the abuser drafted the document for the victim or helped draft the document for the victim, then the second factor would be met. Now, there is some case law that says that if the abuser drove the victim to the lawyer and then sat there and the lawyer did everything, that would not necessarily meet the second factor. So these are very fact intensive, and it depends on how active the abuser was in organizing, drafting, procuring this controversial document. And the last factor is the inequity of the result. Basically, how fair, unfair was the result, and was there an undue benefit to somebody? So again, if you have 4 kids, and maybe normally you'd give the estate to 4 kids equally, that'd be a natural distribution. But one of the kids, drafted a will for mom or took mom to the lawyer, and the will gave everything to that one child. That seems to be unfair, inequitable. Now, of course, if 3 of those kids moved away to other states and 1 kid stayed with mom and took care of her while she was dealing with cancer, et cetera, then it's a situation where, excuse me, that may not be an equitable result. So that may not be unfair. So you really have to look at the evidence regarding the undue benefit. How undue was this benefit? So those are the 3 factors: confidential relationship, actively procured or assisted in procuring the document, and undue benefit. And if the person alleging undue influence can meet these 3 factors, then the burden of proof is flipped, and the alleged abuser has to disprove undue influence, which can be very difficult. This is very complicated, as you've seen. I tried to break it down to the layman's perspective, and I hope that I accomplished that. I don't know, but if you believe that there's some undue influence, or you're concerned that someone's under the undue influence of somebody else, do not hesitate to contact an attorney to ensure that someone's rights are fully represented at all times and fully protected. Thank you so much.